Hey, everybody. This is your daily dose of all things royal. Welcome back, my gorgeous, good looking friends. Before I get started into this video, I just want to make a quick correction from yesterday's video. So, yesterday I'd mentioned that I thought that this footage came from this particular vehicle that was trailing behind the yellow vehicle. However, I saw a clip of the actual video, and it turns out that it came from the yellow car. So that totally blows up my theory that it was someone from Archwell taking this footage. As you can see, it is a gentleman who I have no idea who that person is, but possibly representing this hotel because they took this clip and inserted it into a promotion for the Rosewood Hotel. What is certain was that they used Meghan and Harry as a marketing publicity draw in order to get them to the site. So obviously, this was some type of publicity stunt, as we already suspected, but I just wanted to clarify that. Also, Archie is standing there. Unfortunately, he is being shielded by the bigger girl standing in front of him, but you can see the corner there. His eye is poking out. So now on to today's video. Switching gears, I have an update for you regarding Harry's visa and where it stands with the Heritage Foundation and getting specific information. So, as of June 28th, 2023, the court ordered that both parties needed to file a joint status request on or before July 7th. And the joint status report is supposed to include the status of the Heritage Foundation's request, the anticipated number of documents that were going to be coming towards the plaintiff's request, and then the anticipated dates for the release of the documents requested by the Heritage Foundation. And then there was a decision on whether a motion for stay is likely under Open America versus Watergate, which is the case that they're referencing. So apparently they were given approximately 6 business days to get this together and submit to the court. Here's what happened. This is about to get really nasty. The government is really dragging their feet on this and being quite shady. Homeland Security was also supposed to deliver a joint status response on the 7th, but instead they filed a motion to get an extension to respond. But here is why. The Heritage Foundation doesn't miss this deadline, and they file their joint status report, but they call out the Department of Homeland Security in their statement. Before we look at the Heritage Foundation's filing, let's quickly look at what the Department of Homeland Security submitted and what they had said, so you can see the shadiness of all of this. So in the motion to request getting an extension, they go through the reasons on why and what happened and the timeline. So specifically in bullets number 2 and 3, they say on July 5th, 2023, 2 days before the court-ordered deadline, the undersigned counsel sent plaintiff's counsel a draft of defendant's portion of the status report. So this is what they're saying was done on their side. Bullet number 3, it says, after the close of business on July 7, 2023 at 5:56 p.m., the Heritage Foundation, aka Plaintiff's Counsel, sent the undersigned a draft of plaintiff's portion of the status report and reiterated that it was a draft and that he and his client were still polishing the draft. This draft included 6 pages of inflammatory allegations regarding U.S. Customs and Border Protection handling of the request. So then the Department of Homeland Security says that in contrast, the draft that the undersigned sent plaintiff's counsel on July 5th, 2023, simply included a proposed summary judgment briefing schedule. So this is what the Homeland Security Department saying that they have done and what they've received, and pretty much throwing Heritage Foundation under the bus. In response, the Heritage Foundation was not having any of this and puts the Department of Homeland Security on blast. So in the footnote section on the first page of the plaintiff's status report, here is what they say. So the Heritage Foundation summarizes exactly what was said before regarding Homeland Security filing for an extension. But they decide to clear up a couple things where they say that Homeland Security or defendant claims that Heritage Foundation were tardy in preparing their portion of the draft for the joint statement. But They're saying that that's not the case. Defendant omits that Customs and Border Protection, CBP, issued a revised determination late in the afternoon of July 5th, 2023, which was ambiguous and required 2 calls through the evening of July 6, 2023 to clarify. Put differently, plaintiffs were not even certain as to what the revised determination actually was until the evening of July 6, 2023. Plaintiff's approach is reasonable on that complete timeline. So, as you recall, in the document that the Homeland Security had submitted, they conveniently left out that they submitted this revised determination. So it continues, the defendant's statements that plaintiff's position is inflammatory allegations is simply an effort to distract from the record. ECF number 20, which is the motion for the extension of the deadline. And it says here, all plaintiffs have done is recount CBP's own conduct. Defendant's further suggestion that plaintiff's conduct caused defendant to file ECF number 20 is outrageous on the record discussed herein. More to the point, if defendant had time to prepare and obtain approvals for ECF number 20, which is the motion for the extension of the deadline, it certainly could have drafted the defendant's statement portion of the draft for the joint statement. And how Department of Homeland Security needs 2 business days to respond when it faults plaintiffs for failing to respond in well under 2 business days to a new determination that required 2 phone calls to clarify is unclear. So let's take a look at the document that Department of Homeland Security dropped on the Heritage Foundation in the 11th hour, forcing the Heritage Foundation to have these 2 conference calls because they needed clarity. So let's go through this document that the Department of Homeland Security sent on July 5th. So this new letter that was sent is supposed to serve as an amendment to the May 23rd, 2023 decision in which they affirm that U.S. Customs and Border Protection can neither confirm nor deny the existence of records related to the Duke of Sussex. And as you can see on the right-hand side, this is the letter that they're talking about that's being amended. So the opener has a quick summary of the initial requests and the subsequent appeal that was sought, requesting any and all information pertaining to Prince Harry's immigration status and his filing, as well as his coming and goings in the United States. Now, the Heritage Foundation's position is that this information is important to the public and is of public interest. So that's why they're requesting all these documents. So in the appeal, it says here, your appeal was denied on 2 separate grounds. First, that you failed to provide authorization from the Duke of Sussex allowing for the release of agency records concerning him to you. And second, that even acknowledging the existence of records would infringe upon his privacy interests. More specifically, we found that the request division's interpretation of DHS Regulation 6 CFR was within the discretionary scope of the regulation, and separately, that the agency would neither confirm nor deny the existence of records related to the Duke of Sussex, as doing so would betray the privacy interests protected by the exemptions. Fair enough. So while we continue to assert CBP's interpretation of DHS Regulation 6 CFR was within the discretionary scope of the regulation, but as a stroke of luck, we are now able to acknowledge that certain entry and exit records exist for the Duke of Sussex. CBP continues to neither confirm nor deny the existence of any other requested records regarding the Duke of Sussex, as explained in our May 23, 2023 decision. Well, it's certainly clear that our government is in backpedaling mode because back on June 2nd, the Heritage Foundation pushed back and had specifically said that the counsel for plaintiffs spoke with the counsel for DHS and expressed extreme concern regarding CBP's position in the appeal denial. In particular, counsel for plaintiffs indicated that CBP's action was directly contrary to DHS regulations and that if CBP was going to adopt a construction of DHS regulations that was entirely atextual, plaintiffs may seek to amend their complaint to seek structural relief. Well, the way that I interpret this is they were caught. They could have very well have given some type of information, but decided to give zero information, which was in contrary to what the DHS regulations are. They're saying while they continue to assert CBP's interpretation of DHS regulation, they are now able to acknowledge that certain entry and exit records exist for the Duke of Sussex, but we're not going to tell you what they are. And they continue to stand by protecting Prince Harry's privacy, a self-professed, in the public domain, drug user. Okay. So they go into explaining the type of records that they have on file for the entry and exit. So they found two types of entry and exit records by searching TECS, which is a database, persons encounter lists, and persons encounter detail records. A person encounter list is a list that indicates when a person has entered or exited the United States through U.S. federal air, land, and sea inspection sites, and may include information regarding multiple encounters. A person encounter detail record includes additional travel, manifest, and carrier information for an individual encounter with a person. We are withholding these records in full pursuant to exemptions, and they list them, to protect his privacy. So the exemptions applied to the entry and exit records to protect personal information of the Duke of Sussex and the names and identifying information of CBP employees. The Duke's personal information includes, but is not limited to, the type of document the Duke used to travel, the document's number, document country, and the date and time the Duke arrived in or left the United States, the date he is admitted until, what airport he arrived or left from, his class of admission, etc. I'm assuming that it will also include information about the people who traveled with him. So again, I raise the point, this information could tell us if there were any children on board when he was traveling for the Jubilee last year. So now they go into talking about Prince Harry's privacy and why these exemptions qualify. So they're saying that both the exemptions have been found to protect the privacy interests of all persons mentioned in law enforcement records, including investigators, suspects, witnesses, and informants. Courts have long recognized the mention of an individual's name in a law enforcement file will engender comment and speculation and carries a stigmatizing connotation. Not only the targets of law enforcement investigations, but also witnesses, informants, and investigating agents have a substantial interest in ensuring that their relationship to the investigations remains secret. We therefore find the privacy interests of both the Duke and CBP officers mentioned in the records to be significant. Hold the farm. None of this applies to Prince Harry. He's not a witness in any ongoing investigation. Or is he? Also, is he an agent? Could that be why they're protecting him? Is he working undercover for the US government? This makes absolutely no sense to me, but something smells so incredibly fishy. Our analysis then turns to whether you, as a requester, have identified a public interest sufficient to overcome the privacy interests of those individuals. That public interest can only be the one that furthers the request's lone goal, to open agency action to the light of public scrutiny. Well, yeah, if Prince Harry is admitting to doing drugs and he is with children and influencing them, in addition, Prince Harry is undermining our democracy by participating with NGOs that influence our government policy, that undermines our First Amendment rights. And by doing that under the influence, I do believe that it is of public interest to know whether or not this man is in this country illegally. And if he is, get him out. Now, here's the question. Is he a foreign agent that's being protected by corrupt people in our government, as his role is to destabilize our democracy, which is exactly what him and his wife have been doing around pushing media censorship and restricting and suppressing other opinions and voices online. Not only that, he is a super spreader of pushing out misinformation. So if he is under the influence and he is pushing this out to the masses, it's incredibly dangerous. And that's why the public needs to know. So our government pushing back by saying that the argument of if the Duke of Sussex was granted preferential treatment, that too would undermine public confidence in CBP's application of equal justice under the law. Well, you're damn right. because we see it happening. But anyhow, it says a bare suspicion of agency misconduct is insufficient. A requester must produce evidence that would warrant a belief by a reasonable person that alleged government impropriety might have occurred. Well, here we are, guys. He's been participating or was a part of the Aspen Institute producing that report, which ended up in the Twitter files. Now, here's the interesting thing. At the bottom, it says all persons, baggage, and merchandise arriving in the customs territory of the United States from places outside thereof are liable to inspection by a CBP officer, unless exempt by diplomatic status. All persons entering the United States, including U.S. citizens, are subject to examination and search by CBP officers. CBP officers must determine the nationality of each applicant for admission and, if determined to be a non citizen, whether or not the applicant meets the requirements of the Immigration and Nationality Act for admission to the United States. This is another thing. What if Prince Harry has diplomatic status when he shouldn't have it? As I mentioned in my past videos, that Meghan and Harry came to the United States earlier than what they had revealed to the world. So, what if Prince Harry didn't give back his passport? And what if the United States government did a one off and gave Prince Harry some special type of pass when the Biden administration came into taking over? That is a possibility, considering he has connections all in the right places. Let's not forget that Meghan and Harry were big supporters of pushing people to vote in a certain way. Now, this last paragraph is interesting. They say the fields of data withheld pursuant to the exemption in the person encounter lists and person encounter detail records, which appear in such records for all travelers, are routinely withheld by CBP as they contain otherwise unknown specific law enforcement techniques, procedures, and guidelines followed by CBP when performing its law enforcement mandate of securing this nation's borders. The information indicates what circumstances might trigger additional scrutiny while processing international travelers for entry into the country and provides instructions to CPB personnel related to which law enforcement techniques ought to be practiced in those circumstances. Disclosure of this information would illustrate the agency's strategy in implementing these specific techniques and, in turn, could lead to decreased effectiveness in future investigations by allowing potential subjects to anticipate ... and identify such techniques as they are being employed. You see, like, this is a little bit too much. The Heritage Foundation is not asking for Homeland Security to reveal their secrets on how they look at each individual coming in or out of the country. All they're asking for is to know whether or not he lied on his application. So for them to blow this up in a way that makes it look even more suspicious, I think is going to backfire on them, in my opinion, because this is now going to open up a level of scrutiny amongst the public as to why can't they disclose what Harry put on his application. We simply just want to know if he lied, and if he did, then he should be ejected out of this country. So now going back to this joint status report, the Heritage Foundation calls out towards the end of its document, after summarizing what had happened, to remind everyone Border Protection took the position of glomaring. That's a term that's used in government agencies when it comes to these types of requests, of neither confirming or denying information exists, as another way of saying no comment. Even though they were attempting to allegedly protect Prince Harry's privacy by glomaring all responses when it came towards if the Duke of Sussex applied for entry into the United States and was inspected by CPB, the Heritage Foundation is contesting that a Glomar response is frivolous because, they state here, anyone who is not living under a massive boulder knows that the Duke of Sussex has applied for entry to the United States. His Netflix series, Harry and Meghan Episode 6, opens with a selfie video of HRH flying via private jet into the United States to take up extended residence in Los Angeles on March 14, 2020, at around 6 a.m. Well, I think it was earlier than March 14th, but HRH's international travel is heavily reported by the press. Witness his travel to and from His Majesty the King's coronation, One cannot possibly Glomar such a fact. Pointedly, United States Customs and Immigration Services did not Glomar the request and conducted a search. The only colorable justification for CBP's Glomar is if HRA is here illegally. Is CBP really representing that the Duke of Sussex is or maybe an illegal alien? Guys, this is going to get so ugly because you know what this means. If they succeed in getting the release of these records, we're going to be able to see whether or not Prince Harry and Meghan have been lying this whole time on when they flew over on that freedom flight. Again, my money is that they flew over here earlier than what they're telling the public. As we all know, this couple has a habit of lying on just about everything. So fast forward, they detail the timeline and came up to June 26 when they had a call with the Department of Homeland Security and indicated that Border Patrol was going to be issuing a revised determination, but was not permitted to say more other than an email later that day indicating Border Patrol anticipated sending the revised determination on July 5th, 2023. So the Heritage Foundation had simply asked if the revised determination would alter Border Patrol's legal position, and we're told counsel for Department of Homeland Security could not provide an answer. Okay, fair enough. But then late in the afternoon on July 5th, 2023, Heritage Foundation received the revised CBP determination, and that's what I showed you earlier. Their interpretation of this revised determination is as follows. Border Patrol is abandoning its regulatory argument, and Border Patrol has withdrawn its Glomar as to certain entry and exit records, searched for such records, and withheld them in full pursuant to the exemptions. In essence, Border Patrol has reversed the position it took to moot out the preliminary injunction motion, a position plaintiffs had repeatedly implored Border Patrol to reverse during briefing on the preliminary injunction motion because it was unjustifiable. Apparently, the Heritage Foundation's prediction that a reversal of Border Protection's position would cause delay in setting a briefing schedule has now come to fruition. They're now saying that Border Protection and Homeland Security are deliberately dragging their feet and slow moving. So right now, the Heritage Foundation had been trying to coordinate and schedule a briefing with the Department of Homeland Security to continue and move this forward. And initially, Department of Homeland Security did not want this briefing to begin until September 12, 2023. After plaintiffs objected to this date, the defendant has now offered to begin briefing on August 28, 2023. Reluctantly, the Heritage Foundation agreed to this date, even though they wanted it sooner, and have put together this briefing schedule as seen here. And it states here that should the defendant object to this approach, plaintiffs anticipate raising the matter in their October 2nd, 2023 papers for briefing per the schedule above. Plaintiffs also note that given the conduct of Border Protection discussed above, plaintiffs may seek to alter the schedule to allow for discovery should a factual issue arise that cannot be resolved via declaration. Bet on this is about to get really ugly. And the fact that they have to wait this far to have this discussed and reviewed just only shows that the government is definitely dragging their feet. For what reason? Don't know, but obviously they're covering up something. The American people should really be pissed about this. We need like senators or representatives from the state to speak up. This needs to be taken to our representatives and we need them to speak up. We now have to make noise and reach out to our respective state representatives or reach out to other state representatives if your representative doesn't want to respond because of the political party that they're associated with, because I have that problem in my state. If it is of public interest, then we have to help the Heritage Foundation and speak up and make the noise, because they can't just go off and battle this for us and we sit back and watch and do nothing. We have to give a reason. So if you get the people in Congress to voice their concerns, and perhaps maybe it will push this in a direction to release the information because it is important to the public. Now, this is my prediction, but what I see happening is by the time this briefing begins, and this case gets heard. Harry's going to be somewhere in Africa. I don't think he's going to stay here, especially if this is going on and information is released that he doesn't want to get out, such as those important dates as to when they flew over here and when they resided in Los Angeles, as well as the logs of the people who were on board all those flights back and forth. If Harry is some type of agent, our government might tell him to leave and lay low for a while. Yeah, by the way things are unraveling for Harry, I don't see him sticking around here for much longer. I'm willing to bet that Harry hates America, especially his wife's circle of friends, or I should say, circle of vipers that have been using him and taking his money. That includes his wife. That's just my opinion, but what do you guys think? You know, I want to know, so leave your comments below. But as always, I will be back with more content. But until then, please be safe, and I'll talk to you later. Bye.
It was such a fraud.